Awesome.
State specific. So what happens in Colorado does not necessarily the transfer of a deceased person's assets and estate to someone else.
Okay.
So if you run any need for that in Colorado these days. So.
Yeah. Hi, and welcome to our video series. We're going to be talking a little bit about probate, elder law, trusts, all kinds of stuff. So this is definitely an informational type of a series, and today we're fortunate enough to be sitting here with Renette Greer of Greer Law. And Renette, can you give us a little bit of background about yourself?
Sure, yeah. I am, as you mentioned, an estate planning and elder law attorney. I have my own practice here in Littleton. I focus almost exclusively on the proactive side of things, planning for, with wills, powers of attorney, trusts, as well as more specific situations, whether it's special needs or something like that, some more complex situations, as well as handling the flip side of estate administration or probate.
Gotcha. So all the fun stuff. Right?
Well, I think it is. I think it's important and interesting, and
it's definitely important. Yes. We'll get into that today.
And
for
interesting. Sure. I'm the life of the party.
Awesome. So yeah, we are going to be talking about a lot of stuff, and again, this is for informational purposes only. If you have specific questions, I encourage you to reach out to Renette or somebody else that practices in this arena. But me and my home team, we focus on helping personal representatives do everything other than the law, this side of it. We turn that over to the experts like Renette, but wanted to get a little bit more information out there because there doesn't seem to be a whole lot of conversations around this stuff.
That's true.
And so this first video, we're going to be talking about probate and the differences between that and the living trust, and the options that are there.
Sure.
Can you explain briefly what probate is?
Sure, and I did want to touch upon your point about how there's not a lot of information, or maybe almost too much information.
Sure.
Right? So, estate planning and probate and all of this is state specific. So, what happens in Colorado does not necessarily apply in New York or California.
Sure.
And I think that's a lot of times where there's some confusion surrounding these things. But at a very fundamental level, probate is simply the transfer of a deceased person's assets and estate to someone else.
Okay.
So if you want to think about it, right, in your line of work, right, you handle real estate.
Right.
When someone buys or sells a home, it's done through a signature, right? At the very end of the day, someone needs to sign something for it to happen. And if someone's passed away, there's no one to sign, right? So probate is the process of having someone appointed to step into those shoes, the personal representative or the executor, and they are then able to take those steps and sign on behalf of the estate.
Gotcha. Okay, so that's the legal appointment of somebody that then can sign off on the sale of the assets.
Absolutely.
The estate.
Yeah.
Okay.
Yeah. So.
And there's always talk about potentially wanting to avoid probate. Why would somebody want to do that?
So again, state specific. There are some states like California, New York, lots of others that you really need to avoid it, or you want to avoid it for various reasons. I'm going to speak solely based on Colorado because that's where we are. It's where I'm licensed, and so here we don't have that time-consuming, invasive process that you do in some states. Colorado's adopted the Uniform Probate and Trust Code, which has made things a lot more streamlined.
Okay.
That being said, even though it's streamlined, it going through the process of having the will validated and the personal representative appointed and all of that is time consuming. The average estate process can take about a year, sometimes a little less, sometimes a lot more. But so that's one of the reasons, right? You want to maybe you don't want to be involved in this for many months in an extended period of time, right? So avoiding probate makes things simpler, faster. It's potentially less expensive, and it's also just probate is a matter of public record. So, you know, if someone's interested in finding out, they do a little digging and they can find out. Yeah, absolutely.
Right.
So,
As soon as probate is opened, it becomes public record.
absolutely.
And it's just a matter of going down to the courthouse and
Yeah.
getting copies of the documents that are associated with that. Right?
Yeah, absolutely.
And so then all of a sudden, the personal information is out where maybe you didn't intend it.
Absolutely.
Gotcha. And is there a minimum in Colorado that probate must be open?
So if you can handle assets. Well, it depends, right? So
Okay.
real estate is going to be our big exemption, which is also going to be outside of that minimum. But it is, and I'm going to give this number 80,000, but it's been adjusted for inflation. So I think probably we're right around 95, 100,000.
Sure.
And anything under that can be used with that small estate affidavit, but not real estate.
Not real
And
estate.
not that you can find anything for that in Colorado these days. So
Yeah. That's going to push you over the limit anyway, regardless
Exactly,
of this
right,
sort of
so-
stuff. So a small estate affidavit then is if it's underneath that inflation adjusted number,
Yeah.
and this is being recorded in 2025, just
Yeah.
in case.
and that number is actually pretty good. It dates back quite a while, so it's been adjusted for inflation for
forever.
Yeah,
For a
exactly.
while at least.
Yeah.
But you fall underneath that, then you can file,
Yep.
as long as there's no real estate that's
Correct.
involved, then you can file a small estate.
Yes,
affidavit,
absolutely,
and
and
that
that's
bypasses.
absolutely.
Okay.
So that doesn't need to go to court or anything. So
Gotcha. And then if you're over that minimum or there's real estate that is involved, is there a minimum amount of time that the probate must be open for?
Oh, I see what you're saying. Okay. So yeah, and the answer, the first thing they teach you in law school is to answer everything with "it depends." Right? So if you're opening probate and you are going the informal approach, which is there's a will that names the person, nobody's contesting anything. There's certain dates and deadlines, but one of them is to file a notice to creditors in the local paper. So you just contact them and you'll see that in the classifieds. If you don't file that, then the estate needs to be open for 1 year from the date of death.
Okay.
Otherwise, it's 4 months from the date of that first publication.
Okay.
It's 4 months is kind of a quick turnaround for the most part. Anyway.
That's everything lines out.
Exactly.
There's no contest.
Yeah, so I'd say on average, those if you file that notice to creditors and everything's pretty tied up, neatly tied up,
Right.
then it usually can be settled in about 6 months. But on average, I'd say it's closer to the year.
Closer to the year, which is what you had mentioned
Yeah.
earlier. So that means court filings, dates and deadlines are happening. These actions, the responsibilities of the personal representative are ongoing throughout
Correct,
all
yes.
of those months.
Yes.
And so almost feels like you're kind of continuing to pick at that wound a little bit.
Absolutely.
And, it's tough to move on, have
Absolutely.
closure, or any of that kind of stuff. Because at least on a monthly basis, you're getting reminded of the passing. And the
Absolutely, and especially if your loved one passed away unexpectedly, or there's just a lot of emotions that come with this, and you're not able to fully grieve the loss of your loved one,
Right.
because like you said, there's this deadline, and the attorney's calling again.
Something else
Yeah,
that's going to
exactly.
be required.
Which does make it hard.
Yeah, understand. So that kind of leads me to the next question. Is there benefits of using a living trust versus going down that will route and having
Sure.
your loved ones or the assigned personal representative
Absolutely.
go through that process?
Yeah, for sure. The revocable living trust is the one that's most commonly used in estate planning purposes. So it's nice in that you set it up while you're alive. You can really dial in your distribution. If you have children, you can say, okay, I would like them to receive, 25% at 25, the other half or remainder at 30 or something like that. So you can get really specific, but it's also a living trust, so you are able to use it. You can hold property in it. If you have property out of state, this is a key one. Estate planning, as I mentioned, is state specific. So
Right.
a will only controls assets here in Colorado. So if you own property in another state, then there'll need to be another probate opened in that other state.
Gotcha. So that second home down in Florida, and something along those lines,
Yeah.
you could put that into the living trust,
Yeah.
and that would follow the rules
absolutely.
and stuff here in Colorado, even though it was located down
Yep, absolutely, and it gives you a lot more flexibility in those terms. And so, it also, because you can be really detailed in how you'd like assets distributed or things to just kind of continue on, that after you've passed away, then it allows your family, allows your loved ones to, just follow your instructions, but also gives them time to, grieve and process
To deal with
their
the loss.
emotions. Yeah,
Absolutely.
exactly.
Yeah.
And
That's great. No, you mentioned a revocable versus an irrevocable. With the irrevocable, sounds pretty permanent, and what you put in place is what's staying. Is
yes,
that fair?
absolutely. Yeah. And so there's lots of reasons that makes sense. However, an irrevocable trust, is just like you said, it's irrevocable. So it's set in stone. It's used predominantly if there's special needs considerations, health considerations, creditor concerns. The state tax kicks in now at almost $14 million per person, so that's not so much a concern anymore. But for states that are pushing that limit, then there's reasons to start to look into that. But for kind of the most part, unless we have these special considerations, the revocable trust is the way to go, just because it gives you that flexibility that you need to, because you can revoke it, you can amend it, you can make any changes. You retain full control over those assets rather than transferring them into a different entity where you relinquish that control.
Okay, so in an irrevocable, there's somebody else that's named as the trustee.
Yes.
They then take over the control of those assets that are put in that irrevocable.
It's tough,
yes. And so they become kind of the de facto controllers of those assets.
Right.
They have to follow the guidelines that are set inside that trust. Got it. Okay.
So one thing I did actually want to point out with the revocable living trust, after you pass away, then the trust becomes irrevocable. So no further changes can be made. So that's nice where, maybe your trustee is taking care of minor children and, or maybe there's some concerns of those distributions maybe not being set out the way administered in the way you would like them to be. So this way, once you pass away, then the trust then becomes its own separate legal entity.
Okay.
So,
and what was left at that time, after maybe some amendments or some changes that you were making prior to passing, that's what is left.
Exactly.
Interesting. Got it. So, any simpler alternatives to that?
Sure.
I know beneficiary deeds or
absolutely.
Any other alternatives, I guess, for real estate too? Because
So
you said it wouldn't qualify
exactly.
for the-
So, and I think you mentioned that keyword, right? Beneficiary. So, just like with bank accounts, investment accounts, any sort of financial account has a payable on death or that beneficiary designation. That is something we can also do with real estate. You can do the beneficiary deed.
Okay.
So, I mean, in terms of deeds, right, we have the joint tenancy options, also same with financial accounts. So either where we can address it through joint tenancy or through the beneficiary deed.
Okay.
So
then at passing, it would automatically
Exactly,
transfer to the living,
yes,
person
whether
named
it's
on
the joint,
deed.
whether it's the joint tenant or the beneficiary listed, right? So you would file the death certificate, you'd record that with the county, and then that would just by operation of law just kind of goes that way. You don't have to go open up a probate or anything to transfer the real estate.
Okay. Any downsides to a beneficiary's deed or the joint tenancy that you think?
Well, yes. I mean, so the beneficiary deed, I think the biggest concerns are, first off, if if you are looking to apply for Medicaid down the line, then the beneficiary deed would actually need to be revoked. So Medicaid would be the primary beneficiary if something happened.
Gotcha.
And then my other concern is always, I think about estate planning and all of this on a regular basis. It's what I do for a living. I'm extremely passionate about it. But many people don't, right? It's oftentimes a fix it and forget it kind of mentality. And, if you have a beneficiary deed that maybe you down the line kind of forget that you've gotten out there, and it's maybe now you have somebody else that you prefer to inherit, and just again, you and I think about deeds.
Yeah.
Probably most people don't.
Sure.
And they're like, oh well, yes, then I am now in this new relationship, and my significant other will inherit the property from me. But if you put your kid on the deed, then it's going to them.
Gotcha. And then this may be a question for a CPA, but I know like in a probate deal or something along those lines, the heir would get what was referred to as a step-up basis.
Correct. So that's
at the time of passing, which for those if you're not aware, and again, not accounting advice here, but parent bought the property in 1990 or something along those lines. We've seen massive appreciation over the years. The step-up basis then becomes the new basis for the beneficiary and the heir at the time.
Not for
if it's inherited,
yes,
not as a part of the beneficiaries.
So most often I see this with a joint tenant, like a DIY estate planning kind of thing.
Mm-hmm.
Like, I just mentioned the parent and the child. So, so I heard that joint tenancy bypasses the probate system,
sure,
right? So while it does, you just file that death certificate, and now the joint tenant becomes the sole owner. However, if they didn't purchase the house initially, if it was just a gift, they take the owner's original basis. So that 1990 price for $100,000, and now the property's $1 million. Well, they have that $100,000.
So that can have some massive tax consequences down the line.
Absolutely.
If they're getting that original 1990 value versus the value at the place.
Yeah.
So I mean that kind of goes into my last question was what what mistakes do you see people make in trying to avoid the probate? That would be a massive one.
Yes, absolutely.
Because you just created a huge tax liability for somebody and it was unintended.
Yes, absolutely. It's oftentimes I see that one, I just need to get a will done because I've done everything else. And then as we talk, I'm like, oh gosh, no, let's undo that one, and I need you to live for a few more years. So, but yeah, it's obviously DIY estate planning is a big one, right? Because what maybe worked for your neighbor might not work for you because your neighbor's family is in a different state, or
different concerns,
different
exactly. Assets, different things.
For sure.
So,
and you don't know what you don't know.
Right. The AI lawyers aren't up to speed yet.
I don't typically consult AI lawyers. However, yes, I think we've heard some concerns about AI and it hallucinates and all of these things.
Absolutely. As far as technology has come, there's still some major holes that's a part of it.
Some limitations for sure.
And depending on whatever AI you're using, the data that it was trained on, how outdated is it? I mean, how often are laws changing in probate?
not too often,
Okay.
but it's
There's different nuances.
Well, I think the biggest thing that I've run into is that since you don't know what you don't know what questions should be being asked,
Right.
and if and I see this a lot of times with documents, not even necessarily AI, just LegalZoom or
Some of those internet companies.
exactly that they are drafted to kind of cover all situations, but you might be the exception to that rule, but you don't know that you're the exception to the rule, right? So I think it's really important to sit down and have these conversations, just as a society as a whole, where like this is, we are all, as much as we'd like to think we're going to live forever, that's something that we haven't figured out how to do yet, for better or worse. But,
Right.
and I think it's becoming more of an acceptable topic, right? But it's holistic, right? So, there's real estate, there's financial, there's, the estate planning laws, and I think it really all needs to flow together, and we need to have these conversations and look at the bigger picture.
Absolutely. Awesome. Well, there you have it. There's video 1 of our series here today. There's differences, there's options. You can go the probate route, you can go the trust route, you can go some other routes, but it really is, as you said, an individualistic kind of approach, and should be tailored to the individual and their situations and what their family, estate, and everything else.
Yeah, exactly. Personal preferences and everything. There's a lot that goes into it.
Great. Well, thank you for your time today.
Absolutely.
Make sure you come back for the second series. We're going to have a couple of these videos that are out there. We'll dig into some other topics that you may not be aware of.
Thank you.